Good evening, everybody, and thank you for joining us on this really nice spring evening for something even more exciting than being out in the nice weather, which is the talk we've got today on construction law update. So really looking forward to our event this evening. Just falls to me as the chairman of this branch, Thames Valley branch of the CI Hub, to welcome you all. Thank you for joining us, particularly those online. For the benefit of those online, we will be able to respond to your questions, but we ask that you use the question and answer box on the Zoom. So there's a question and answer box. If you put any questions in there, what we'll do is we'll wait to the end and then we'll allow our speakers to take any questions which you may have or as many as we can deal with. Just to give a bit of a brief introduction to those who are not familiar with this branch, with the CI Hub, we are the Chartered Institute of Arbitrators, but we are certainly not all arbitrators. In fact, that's probably a minority of our members now. We have a wide range of arbitrators, people involved in mediations, adjudication, and expert witness. In this branch, we do have a bit of a construction law focus, or a bit more of a construction law leaning, but we're not exclusively construction law, and there will be talks throughout the year which touch on a wide range of topics, one coming up which I'll talk about in a minute, on the impact of AI, for example, which is not construction based. So we definitely do construction, but we definitely do wider areas of law as well. So thank you. And the branch itself, as you'll see on the slide, covers Berkshire, Buckinghamshire and Oxfordshire, and we try and meet around the branch. So today we're up in Oxford, which is brilliant. We regularly meet at Maidenhead, we meet at Milton Keynes. So we get around the branch, we try and get to as many areas as possible and hope to attract as many members and non-members. And we often have non-members joining, which is fantastic for us as well. So fantastic to see you all today. Just a couple of updates before we get going. The first is that we've got an upcoming event on the 30th of April, which is our AGM. So we'll be having our AGM prior and then we'll talk afterwards, which I'll be giving on the payment notices. And we'll be looking at how the courts have developed their approach to interpreting payment notices and how that aligns with the House of Lords authorities and what's gone before. So that'd be really interesting. And that's at the Maidenhead Golf Club. And then in May at EMW Solicitors in Milton Keynes, we've got AI in dispute resolution, which I alluded to. So that'll be slightly different to some of the stuff we've looked at. Certainly looking forward to how that's going to unfold and that talk. So really hope to see as many of you there, many of you in the room would be ideal, or online at those events. So it just falls to me now to introduce our speakers, who we're really grateful to come in tonight and speaking to us on this topic. Dominic is a partner in the Oxford office of Mills and Reeve, and Alison is in the Cambridge office, and both specialise in construction and engineering projects. So they're definitely the right people to be speaking to us on this topic, and that's great. Was talking to Dominic and Alison just before we kicked off, and we try and ask if there's anything we can tell the audience to humanise them and understand them. Unfortunately, what we had was Dominic telling us he's swum the channel, so something else that I won't be able to do either. And Alison will be shortly following in his footsteps because she's having swimming lessons. So hugely accomplished in many respects, our speakers tonight. And yeah, so we're really grateful to have them. And I'm going to get out of the way and let them take over. So please welcome them and good luck. Oh, thank you. Thank you.
Going to flick us onto the other slides. But thanks very much, James, for the introduction. Thanks to the Thames Valley branch for having us. Thanks to everybody for attending in the room, and good afternoon, evening, morning, wherever you are, to those online. The slides will pop up, and I'm glad to see that the billing here is developments on construction law in 2025. I think the brief we were given was a bit broader. I think it was from 2023 to the last 24 months. There's an awful lot to cover, and as you'll imagine, this will be a whistle-stop tour of the highlights rather than going into detail on every change. We're also not going to talk about the Building Safety Act 2022. The reason for that being, I understand that the Thames Valley branch has organised or delivered a training on the Act. But you will find that a number of the cases that we talk about sort of flow from changes introduced by the Act. If you've forgotten anything from that training session, I'll mention that we have just launched a series of podcasts on the Building Safety Act and how it's playing out. They're brief, sort of 10-15-minute sessions, and there'll be a link at the end of the slides to those. So what we're going to aim to cover today, and Alison and I are going to tag team as we walk through this agenda. First, Alison's going to talk about the seminal case of URS and BDW, which was an appeal to the Supreme Court, heard in the Supreme Court in December 2024, and the judgment is awaited. We did check, I checked this morning, I think you checked more recently. It's any day now, but the Supreme Court's judgment has not yet been handed down.
I'm rather grateful that it wasn't handed down this morning.
Exactly. So after that, I'm going to pick up on 4 cases of some broad application, hand back to Alison to explore some of the case law emerging from the Building Safety Act, back to me for another 4 cases, this time on the issues arising from the JCT forms of contract. Finally, back to Alison to round off with some comments on compulsory mediation. So with that, I'll ask Alison to take the stage.
Thank you very much, Dom. Right, yes, as I said, as Dom has just said, the first case I'm going to talk about is URS and BDW. And the reason we've set this out separately from other cases is because it is so important. And even though we haven't got the Supreme Court decision yet, it is still hugely important in terms of the legal position on 4 particular points that were raised by it. As I said, no Supreme Court decision, thank God, this morning. So we are still working on the basis of the Court of Appeal decision, the leading judgment of which was given by Coulson LGA. I'm sure you're all familiar with him, and if nothing else, you're aware of his book on adjudication, Coulson on adjudication. The issues before the court were all preliminary issues, so please bear that in mind as I go through all 4 of them. In the time available, I'm going to spend more time on 3 of them rather than the 4th, because I think they may be more applicable to you than the 4th, but I will touch on it. I wouldn't normally spend any time going through, or much time going through the facts of a case, but I think here it is important to do so. And the reason is that the facts, I think, probably influence the court a bit, and they're also slightly unusual in some respects. BDW, most of you will know of, they own Barratt Homes, they own John Wilson Homes, and actually I will refer to BDW when it comes to other cases as we go through this seminar. URS are consulting engineers, they're now owned by AECOM. BDW appointed URS on a number of projects, including but not limited to Capital East on the Isle of Dogs and Freeman Meadow in Leicester. Now, I will set out on the slides, as you will see, a short time frame because it's important to understand the time frame in relation to this case. Between 2005 and 2012, BDW completed on apartments in both these blocks of flats, and subsequent to that, in 2017, and it's not on the slide, but in 2017, we had the Grenfell fire tragedy. At some point before 2019, BDW divested itself of any interest in either building, but it decided that it should investigate, despite the fact it had no proprietary interest, it should investigate as to whether there were any defects in these buildings in the light of Grenfell. There were no obvious signs of defects, but it undertook inspections. And those inspections revealed that in relation to the structural design, it had been negligently performed and that it was dangerously inadequate. But there was no actual physical damage at this point. Despite this, BDW chose to do remedial works. No one made a claim against them at this point. They just chose to do the remedial works. And just before COVID, on the 6th of March 2020, they then issued proceedings against URS in tort for negligence because the time-framing contract had expired. Well, that appears to be the case. 2 years later, the Building Safety Act came into force in June 2022. And I will touch on this in a bit more detail, but as you probably are all aware, one of the things the Building Safety Act did was to extend limitation through the Defective Premises Act, 1972. If, like me, you've spent most of your working life being aware of the Defective Premises Act, but it never really holding much thought in your mind, I think this is all about to change. And the only time I'd ever come across it was a little old lady in a cottage in the 1980s sometime. It's taken on a whole new world. Anyway, the government has used the Defective Premises Act as the means of extending limitation through the Limitation Act, and I'll talk about that in a bit more detail. But the reason that it's important here is because proceedings had been issued before it came into force. And the first of the 4 arguments that the court was faced between URS and BDW was about amending the pleadings. So unsurprisingly, BDW wanted to amend its pleadings to include reference to the extended limitation period granted by the Building Safety Act. URS's position was that the extension of the limitation period could not apply because proceedings had already been issued before the Building Safety Act came into force. Now, remember, this is a preliminary issue point, and what the court's decided, what the Court of Appeal has decided, is that it's reasonably arguable that BDW can rely on the extended limitation period, even though proceedings were issued before the Building Safety Act came into force. So that's the first point to be aware of. The second point is about the Defective Premises Act itself. And it was URS raised the issue of whether, in fact, BDW could rely on the Defective Premises Act because they were a developer. They weren't someone they claimed who was owed a duty under the Defective Premises Act. Back to my little old woman scenario, I think as much as any of us gave any thought to the Defective Premises Act, we used to think of it as somebody living in the property being able to have a claim in relation to that fact that that property was not fit for habitation. However, if you look at Section 1 of the Defective Premises Act, Section 1A, a person taking on work for or in connection with the provision of a dwelling, whether the dwelling is provided by the erection or by the conversion or enlargement of a building, owes a duty if the dwelling is provided to the order of any person. Now, of course, these dwellings had been provided to the order of BDW, and the court, perhaps unsurprisingly, took the view that a developer was entitled to benefit from the Defective Premises Act, was entitled to bring a claim under the Defective Premises Act. Third point, and probably the most important point, and the one that's probably engaging the Supreme Court the most, was about the cause of action. Now, this involves a little bit of mental gymnastics. URS wanted to argue that the cause of action accrued when BDW discovered the defect. And that's one of the reasons, or the defects. That's one of the reasons that I put the timeline on my first slide. We know they discovered the defects sometime after 2017, and at a point when they no longer owned the building. And of course, if that were the case, then although the cause of action arose at a point when BDW did not have a right to bring a claim. All very theoretical on one level. BDW argued that the cause of action arose at practical completion. At that time, it did own the buildings. And the Court of Appeal, after some consideration, decided that in fact the cause of action did arise in tort at practical completion. This aspect of the case is likely to attract a lot of attention from the Supreme Court. It is considered likely that they will reverse or may consider reversing the case of Pirelli versus Oscar Faber, which is a 1980s case, which decided that the cause of action accrued either on completion, if a project was doomed from the start, which is unusual, or more commonly, when physical damage occurs, regardless of when knowledge of the damage arose. Pirelli was decided before the law on economic loss was fully developed, and for that reason, if for no other reason, it seems likely that the court will change or look at this in a lot of detail when we get their decision. And the fourth point, which I'm not going to spend a lot of time talking about because of, I'm trying to restrict this to an hour, Civil Liability Contribution Act. URS thought to claim that as no one had made a claim against BDW, and that it couldn't bring a claim against it under the Civil Liability Contribution Act, which might have given it another extended limitation period, they argued it was a condition precedent that someone had brought a claim against you in order for you to be able to rely on the Civil Liability Act. Perhaps bearing in mind the way the rest of this judgment went, you won't be surprised to hear that the court held there was no such condition. Probably not the most key point for you, but something just to bear in mind. Dom, back to you, I think.
It's back to me. The key cases, as we've headed them. So I'm going to talk through 4 cases of general application, mixed bag of issues covered here. The first is the case of Thompson and Rolls-Royce Motor Cars Limited. This is not a construction case, but it's a Court of Appeal judgment relevant to any commercial contract that includes a cap on liability. And the brief facts are that Rolls-Royce engaged Thompson to provide digital visualization software to allow customers to see realistic models of the cars that they were thinking about buying. So I'm envisaging some kind of a digital twin type arrangement. And Thompson failed to meet program milestones in the contract, and as a result, Rolls-Royce terminated the contract. Thompson then issued proceedings for unlawful termination, and Rolls-Royce counterclaimed for losses arising from the termination. Mrs. Justice O'Farrell, in the TCC at first instance, decided that Rolls-Royce had validly terminated the contract and was entitled to approximately 8 million euros in termination damages. She also decided that at the date of termination, Thompson was entitled to a further payment of approximately 800,000 euros. The contract also included a cap on liability and a provision for set-off. The liability cap limited each party's total aggregate liability to 5 million euros. And the key issue in this case, for our purposes at least, is the interplay between the liability cap and the question of set-off. And there were 2 interpretations presented to the court on that point. The first, proposed by Rolls-Royce, says that the set-off exercise should be carried out before the cap is applied. And on the numbers in this case, that results in a net liability position of 7.2 million euros owed by Thompson to Rolls-Royce. Rolls-Royce's argument is that you then apply the liability cap, bringing that 7.2 million figure down to 5 million. And that's the sum that Rolls-Royce said they should recover. The second approach, Thompson's alternative reading, was that the cap should be applied to each liability first, and then those liabilities, having been capped, would be netted off against one another. So on that basis, Rolls-Royce was owed a liability of the 8 million figure, which is capped down to 5 million. And the sum due from Rolls-Royce to Thompson, sorry, the 800,000, similarly capped, but that's well below the 5 million. So the cap is irrelevant there. Rolls-Royce's capped liability of 5 million is then reduced by the sum outstanding to Thompson, giving a net liability of 4.2 million euros. So you end up, you can see very clearly, with an 800,000 euro delta between the two positions. I can tell you that Mr. Justice O'Farrell in the High Court and Lord Justice Coulson in the Court of Appeal each came to a different conclusion on which of these was the correct interpretation. And you've guessed it, I am going to ask those in the room to be the judge in this case. So by a quick show of hands, who would go for option 1? 1. Okay, we have a few over here. And option 2? Very good. Well, the option 2 group, you're straight to the Court of Appeal. Option 1, stay in the High Court for a little bit longer. This was the answer that was given. And I'll give a brief summary of the reasoning. But the Court of Appeal reached the view that option 2 was the correct interpretation based on the words that were used in the contract and the fact that those words gave an outcome that accorded with commercial common sense and was in line with the only jurisprudence on the point. In relation to the words used, Lord Justice Coulson noted that there was nothing in the drafting to say that the cap should apply to a net financial position. The contract could have said exactly that, if that's what was intended by the parties. Instead, it referred to the total liability of each party to the other. And the Court of Appeal decided that that wording assumed there could be 2 separate liabilities, each of which would be the subject of the cap. And that led to this approach to netting off. There was a further issue, which I'll only mention briefly, around whether interest for late payment then fell within the cap. And as I say, just briefly, the court decided here that interest was additional to the capped liability, that clear words would be needed if the intention was to deprive a party of a common law right, which was then described in the contract as a sole and substantial remedy. And the court also noted that including interest within a cap could act as a perverse incentive in circumstances where payments were getting close to that cap level. For the next case, I'm going to rattle through these, given timings. Venker and Marbank. This is a long, fact-heavy judgment given by Mrs. Justice Jefford in the TCC. And it relates to a claim brought by homeowners, the Venkers, against their building contractor, Marbank, their architect, SCD, and their contract administrator, Mercer and Miller, although the claim against Mercer and Miller was actually settled before the case went to trial. I think this is an image of the house, which sounds from the judgment as though it was meant to be idyllic, but was fraught with difficulties. As I say, it's a wide-ranging judgment, worth a read as it deals with a range of issues around obligation to mitigate, contribution between defendants, effective pre-trial settlements in the context of multi-party actions. But for today's purposes, I'm going to focus on certain elements that related to a claim pleaded under the Defective Premises Act 1972, which Alison has mentioned. And the context here is exactly as Alison has said, that the changes introduced by the Building Safety Act do seem to be making the Defective Premises Act a more appealing route for some claimants. So Section 1, which is not new, has always created a duty to carry out work in a workmanlike or professional manner with proper materials so that a dwelling is fit for habitation. And this applies only in respect of the provision of a new dwelling. Section 2A, introduced by the Building Safety Act, now fills that long-standing gap by extending the duty so that it also applies to work on existing dwellings. And the second key change is an extension to the limitation periods, which Alison has mentioned. So the Building Safety Act amends the Limitation Act so that claims under both Section 1 and Section 2A of the Defective Premises Act now have a limitation period of 15 years from the date when work is completed. And that period is extended to 30 years in relation to causes of action under Section 1 only, provision of new dwellings, where the cause of action arose before the date that the Building Safety Act came into effect, so the 28th of June 2022. Now, the reason for mentioning these extensions is because they were important to the Vainkers, because their claims against their architect, SCD, in contract and in tort were out of time. But due to the longer statutory period, a DPA claim was still available. In respect of that claim, the judge dismissed arguments relating to brickwork and structure because they didn't render the dwelling unfit for habitation. But she found for the claimants in respect of SCD's inspection obligations relating to the glass balustrade. And there are two key points to flag here. First is about the assessment of loss. And in relation to the process for assessment of loss, the architect argued that replacing the balustrade would be disproportionate because installing a simple handrail would remove the danger, render the house fit for habitation. That's all that was required. The judge disagreed with that, finding that this may be an aesthetic consideration, and that wouldn't be sufficient to offend the duty to provide a dwelling that is fit for habitation. But once that duty is breached, once the liability is established under the Act, then the measure of damages looks at the cost to put the property into the condition that it would have been in if the work had been carried out in that professional and workmanlike manner required by the Act. And the second point is that the architect's appointment, which was a Reeve 2010 form, included a net contribution clause. In relation to this, Mrs. Justice Jefford considered Section 6.3 of the Defective Premises Act 1972, which is on the screen there, and provides that any term of an agreement that seeks to exclude or restrict the operation of the Act will be void. And applying that wording to a net contribution clause seeking to limit the architect's liability, the judge had little difficulty really in holding that the provision was of no application to the Defective Premises Act claim. So another possible reason that claimants might consider pursuing action under a Defective Premises Act where available in parallel with claims in contract. Finally, quick note that this case doesn't settle conclusively the perennial debate on whether the Defective Premises Act creates a strict liability. There are some references to the use of skill and care that suggest possibly not, but those would be open to comments in any event. It is clear, however, that the requirement to act professionally or in a workmanlike manner and the requirement to provide a dwelling fit for habitation are two elements of a single composite duty. The third case in this section is Reeve and HCC International Insurance, and another, which is relevantly here, a firm of solicitors. And it's worth setting out the fact pattern briefly here. So Ms. Reeve contracted to purchase a property on the strength of a valuation to the tune of £8 million by Gold Plaza. Turned out that that was a significant overvaluation, as a result of which Mrs. Reeve couldn't complete on the sale. She wasn't able to sign that contract of sale. She ended up negotiating with the seller, agreed a settlement and that settlement required her to make a payment of £2.2 million. When she looked at who she might recover that money from, she found Gold Plaza had gone into liquidation. So took advantage of the Rights Against Insurers Act to pursue a claim against Gold Plaza's insurers, HCC. And although it's a 2010 Act, it only came into force in 2016, I think August 2016. So maybe one reason that this hasn't seen as much judicial attention. The final complicating factor or relevant factor in the fact pattern is that Ms. Reeve had also employed a firm of solicitors who remained solvent, and HCC sought a contribution claim from that firm of solicitors in relation to the loss that Ms. Reeve was claiming against their insured, and by virtue of the Act against HCC. So the key issue here relates to the interaction between these two pieces of legislation. The Rights Against Insurers Act enables a claimant to sue an insurer directly where the insured defendant is insolvent. The Contribution Act applies where more than one party is liable to the same person for the same loss, and it permits a defendant to recover a contribution from others who share that liability. In this case, as we've said, the insurers were subject to a claim under the Rights Against Insurers Act. They sought to join the solicitors to the proceedings on the basis of a Contribution Act claim. And Master Brightwell found that the contribution claim failed because it failed this test on whether or not you're talking about the same damage. He observed that the insurer, HCC, hadn't inflicted damage on anyone. The only damage that an insurer could inflict in these circumstances would be if they refused to meet obligations under the insurance policy. So if Gold Plaza had remained solvent, they may have had a contribution claim against the solicitors based on the liability of both firms to Reeve in relation to the loss she had suffered. But the insurer didn't owe that same loss. The insurer's duty arose under a contract of insurance. It owed a duty to Gold Plaza and not to Miss Reeve. So yes, the Rights Against Insurers Act enabled Miss Reeve there to stand in the place of the insured for the purposes of this recovery action, but it didn't operate to put the insurer into the shoes of Gold Plaza for all purposes, including for the purposes of a contribution claim. And I think this finding is worth bearing in mind because contribution claims are very common in construction disputes, and insolvency, I would say, is not uncommon in the construction sector. So it may feel like an odd collection of facts, but I don't think it's that unusual, and it could arise. So where do we go from here? Well, there's been a lot of debate, as you'd imagine, among insurers and those who act for insurers about the impact that this decision will have. And many commentators are anticipating that there will be an appeal against it. For the time being, without legislative reform, it does appear that an insurer's best course of action when faced with a liability by virtue of the Rights Against Insurers Act will be to pursue a separate subrogated claim against another party paying an obligation. For the time being, this seems to set a pretty clear distinction between liabilities under the Civil Liability Act and the Rights Against Insurers Act. The fourth and final case for this section is one that you will probably have heard about every time you've been to a construction law update for about the last 5 years. But we now have a judgment from the Supreme Court on the question of whether a collateral warranty can be a construction contract for the purposes of the Construction Act. And the significance of that question, of course, arises from the fact that a construction contract will permit the parties to refer a dispute to adjudication. if it arises under a construction contract. So section 104 of the Construction Act on the screen here says that, I'm not going to read the whole thing out, but in effect, a construction contract is an agreement for the carrying out of construction operations. And recall this word "for" because it does quite a lot of work in the court's reasoning. So in short, the Supreme Court held that a collateral warranty can be a construction contract within the meaning of section 104, but only if the warranting party gives a contractual obligation to carry out construction operations that is separate and distinct from the obligations arising under the underlying contract or appointment. Where, as is the case with most warranties that we see, the warranting party is merely warranting performance of obligations that are owed to an employer under an underlying contract or professional appointment, that warranty, without more, will not be an agreement for the carrying out of construction operations. So there's some good, I think, common sense around that. The debates in the lower courts around the timing of when the warranty is given, whether the word undertaking is used in the warranty, whether obligations are described in forward-looking terms or backward-looking terms only. Those considerations were addressed by the court but not considered decisive. The key is whether there is a separate and freestanding obligation under the warranty to carry out construction operations. And on that basis, the Abbey warranty that was considered here was not a construction contract. And a corollary of that reasoning was that the decision in Parkwood and Lang O'Rourke was overturned. So we now have some clear judicial guidance that most collateral warranties will not entitle parties to adjudicate disputes arising under them. And if parties want that right to be available, they will need to include express drafting in their warranties to that effect. I think that brings me to hand back onto you, Alison.
Thank you, Dom. We said we wouldn't talk too much about building safety, and I promise you we won't. But you can't at the moment, I think, give a talk on a constructional update without referring to it a bit, I'm afraid. I'm going to touch briefly on the extensions of limitation, which Dom has mentioned, and just give some live examples. And then I'm going to talk a little bit about what I've called building safety orders. I don't think as a group you need to particularly concern yourself about remediation orders or remediation contribution orders because they're made by the first tier tribunal. But there are some similarities between remediation contribution orders and building liability orders. Building liability orders are made by the High Court, but I think they may, well, are likely to impact you. And then I'm just going to touch on a case called BDW versus Ardmore, our friends BDW again. There are actually already 2 decisions on this case, but it's it's the first of those 2 decisions that I want to talk to you about in a bit more depth. So extensions of limitation, this, as Dom has said, has been, limitations been extended by the Building Safety Act to claims under the Defective Premises Act in 1972, which has been widened. So the Defective Premises Act relates to new builds or related to new builds, but as a result of the Building Safety Act, it also applies to extensions to existing buildings as well. In theory, there's also been an extension of limitation through the Section 38 of the Building Act 1984, but that's not yet in force. 1984 was a long time ago. We did think that perhaps it would come into force after the Building Safety Act in 2022, but not as yet. Wanted to mention a couple of examples of claims under the Defective Premises Act, a duty to build dwellings fit for habitation, so you've got to have dwellings within your building. For claims which accrued before the 28th of June 2022, in relation to new builds, there's a limitation period of 30 years. How that works in practice, practical completion, if it occurred in June 2000, the limitation period won't expire until June 2030. And if practical completion occurred in April 2022, we think time expires in April 2052, and that's sometime hence. Bear that in mind when I tell you that for claims which accrued after the 28th of June 2022, either for new builds or the new introduced existing build claims, 15 years. That leaves you with a practical completion date of July 2022, with limitation expiring in July 2037. I just go back to my previous slide. If you had practical completion in April of 2022, you got a limitation period of 52. I mean, there had to be a divide somewhere. Dom and I spent some time scratching our heads to consider whether this is really right. We think it is.
I think it means that a 2-day difference in practical completion date can mean a 15-year difference in limitation.
I'm not going to really go into this in detail because I'm not sure that there are that many claims that you will have come across yet, but the construction, there have been extensions to the limitation period for construction product manufacturer claims as well, 30 years for claims in relation to cladding products if the action occurred before, the cause of action accrued before the 28th of June 2022, 15 years going forward for construction products for claims that accrued after the 28th of June 2022. So note the difference, cladding and construction. Yeah. I said I'd talk just very briefly about remediation orders and remediation contribution orders. When I was preparing for this talk, I had thought that I might mention some of the many remediation orders that have now been decided. I think in every single case that I've seen, a remediation order has been granted. And there's now quite a collection of remediation orders that have been made. But it's not, as I say, likely to impact you. It's a first-tier tribunal that makes the decision. That's also true of a remediation contribution order. As I said, there are some similarities with the building liability order, but the only thing I think worth mentioning to you in the time available is there is a requirement that the order, it must be just and equitable to make an order for a remediation contribution order. And that's also true of a building liability order. What is just and equitable? We don't know, but we might find out when triathlon, which is a case concerning the Olympic Park, goes to the Court of Appeal. So, building liability orders, why am I concerned about them in relation to you? Well, hopefully you'll find out in a moment. The High Court may make a building liability order if it considers it just and equitable to do so, and also that in a building liability order is an order providing that any relevant liability, bear that in mind, of a body corporate relating to a specified building is also a liability of a specified body corporate. What that means in plain English is that the Act pierces the corporate veil. So that if a party is liable for a particular relevant liability, its parents, its subsidiaries, its sister companies can be the subject of a building liability order. So this is also true of remediation contribution orders, but it most firmly pierces the corporate rail, and that's its intention. What is a specified body corporate? Well, it has to have been at the time between the beginning of the carrying out of the works and the ending with the making of the building liability order associated with the original company. And as I've said briefly, associated for the purposes of a building liability order, parent, sister, subsidiary. Beware that there's a different definition of associated for a remediation contribution order. It's even wider for a remediation contribution order. What is a relevant liability? Well, we're back to our friends, the DPA, a liability under the Defective Premises Act or Section 38 of the Building Act, or as a result of a building safety risk. And a building safety risk is a risk to the safety of people in or about a building arising from the spread of fire or structural failure. Important point to note here, and it sort of gets lost a little bit, is that it's not limited to dwellings. You don't have to have a dwelling in your building, and it has no limit on height either. So in theory, it could be an office block that's 2 stories tall. BLOs can only be made by the court. The cases so far have not dealt with the possibility that the liability is established through arbitration. And this is where I think there's some unfinished business, shall we say. They've suggested that a building liability order might be part of the court proceedings to find whether the main defendant is actually liable. If you've got an arbitration clause in your contract, you're not going to be able to do that. And it seems to me that what will happen is that you'll have to proceed to arbitration to get a decision against the main defendant. And if a decision is obtained, then a party will go off to the court to seek a building liability order. That will mean 2 things for arbitration as far as I can see. One, in those circumstances, it's likely to take much longer than if you were going through court proceedings. The second point is that parties often choose arbitration because it's private, and while you'll be still able to keep the arbitration itself private, the application for a building liability order before the court will not be private, and who knows how much will come out in those court proceedings. So something to be aware of. And the last point, the penultimate point is, how will this work in relation to adjudication? We don't know yet. Will an adjudicator's decision be treated as a relevant liability, entitling the party to a building liability? We don't know. I've listed at the bottom the 3 cases on building liability orders that have been made to date. Not sufficient time to go through them, but just be worth being aware of them. It includes the second decision in the case of BDW versus Ardmore, which is my final point to make. This BDW versus Ardmore was the enforcement of an adjudicator's decision. It was arguably over whether the adjudicator had jurisdiction under the Defective Premises Act again. And a distinction was Ardmore would bring a distinction between the wording under the adjudication clause, which said that disputes were referred to adjudication arising if they arose under the contract, which is the wording of the Housing Grants, Construction and Regeneration Act, and under the arbitration clause, which referred to disputes arising under this contract or in connection therewith. I don't suppose many of you in the room will be surprised to hear that the court felt that there was no difference in relation to that. And I have put on the slide exactly what the judge had to say in relation to that. I find there is no significance in the differing wording in the arbitration and adjudication provisions of this building contract. What does that mean? Well, it seems to me there's nothing to prevent adjudicators considering claims under the Defective Premises Act. And if that's the case, they'll be considering claims with the extended limitation period, 15, 30 years. It wasn't alleged in this case, although some of you might think it feels a bit unfair. There was no argument about breach of natural justice due to the passage of time. But in fact, Ardmore had completed these works in 2003, 2004. They got notice of adjudication 2 years after the Building Safety Act came into force on the 21st of March, 2024. But as I say, it was accepted by the parties that the case was historic and was not in itself a natural justice objection. It's on appeal to the Court of Appeal, due to be heard before the 7th of April 2026. So don't hold your breath. Don, back to you with JCT.
Is it? Back to JCT. conscious of time, I think we're going to rattle through some of these. So 4 JCT-related cases. The first is John Siskinson and Capital and Centric Rose Limited. This was a Part 8 claim for declaratory relief on the proper construction of an amended JCT Design and Build 2016 contract. And the question was how responsibility for existing structures was allocated between the parties. There are a number of chestnuts in this case as we go through. The terms of the schedule of amendments placed wide-reaching responsibilities on the contractor, CISC, but those obligations were made subject to a set of clarifications, which were defined as the clarifications headed contract clarifications contained in the employer's requirements. And the next part of the story may feel a little bit too relatable to some. Would you believe that there were 2 clarifications documents? One was the contract clarifications and the other was headed tender submission clarifications. The contract clarifications and the tender submission clarifications appear to set out diametrically opposed positions on the allocation of existing structures risk. So the contract clarifications documents describes that as an employer risk. The tender submission clarifications stated that the employer would categorically not accept a blanket exclusion on existing structures. It gets better. There was an electronic version of the contract and a paper version of the contract. Now, both clarifications documents were included in the USB drive containing the electronic version, but only the construction clarifications document was included in the printed paper version. There's some knowing nods in the room. Yeah. Where are we? Yes, we have a decision of the court here that the contract clarifications document was the relevant document that qualified the drafting and the schedule of amendments. And it was tolerably clear from that document that the intention was to place risk arising from unforeseen issues in the existing structures on the employer. And the decision is, in a sense, quite fact specific. So there are just a few points that I'm going to pull out and talk through. The first is that the court reaffirmed the well-known position that with limited exceptions, evidence of pre-contract negotiations is not generally admissible to aid interpretation of the concluded contract. But interestingly, it also explained that this prohibition doesn't result in injustice for contractual parties, and that's because claims in estoppel or for rectification of contract terms are available, and they operate as safety devices where pre-contract negotiations evidence can be admitted. So the policy point really is around, in a normal claim, saving time and cost. We don't have admission of pre-contract negotiations, but that doesn't mean that you can't. If you need to, you have to argue rectification or estoppel. In relation to incorporation of documents, I think from the nods in the room, we all recognise this is a salutary reminder to those of us involved in drafting contracts and in putting together packs of contract documents, just to make sure that it's clear. It's clear enough which documents are intended to be included in that contract pack. And just briefly, because it made me chuckle, the court also commented that deciphering the intention recorded in the contract was made more difficult by wording that was not a model of linguistic clarity, which I think is a polite way of putting what was put in some of these documents. Yeah, there were no definitions of existing structures risk and employer risk anywhere in the contract, but the judge did find that they could reasonably obviously be understood in the context of construction contracts generally as referring respectively to the contractual risks associated with the condition of existing structures, which was a defined term, and the contractual risks accepted by the employer. We now move on to the second case, which is place first construction and car construction. And this is a good reminder about payment provisions under the Construction Act. Maybe something that you'll come back to in your talk later in the year. Specifically, it's a reminder around the requirements in the Act that a party is obliged to pay the notified sum on or before the final date for payment, which is under section 111(1). The notified sum may be identified in a payment notice under section 110A, a pay less notice under section 111(3), or an application for payment if that becomes a default payment notice under section 110B. So the facts of this case in brief: place first employed car under an amended JCT design and build form of subcontract. That obliged car to submit interim payment applications each month, no later than the 25th of each month. Place first was then required to issue a payment notice not later than 5 days after the due date, and the amount specified due for payment on the final date for payment. Nothing surprising there. PCL also entitled to issue a pay less notice no later than 2 days before the final date for payment. Facts of this case: on 24th of July 2024, there was an application for payment submitted. And on the 31st of July, Place First sent an email enclosing what was referred to as a pay less notice, and also attaching a separate document that was titled Valuation 30. And those documents taken together contended that no payment was due in respect of interim application number 30. Carr said that the payment notice had not been validly issued, and that the pay less notice had to be disregarded because it had been issued by PCL too early, before the date when it could properly be issued under the Act and under the contract. The court held that the pay less notice was valid, even though it was issued before the due date. The only restriction arising from the Act is that the notice must be given after the application for payment, which contains the sum that could become the notified sum as a default payment application. Also held that the payment notice was valid. It looked at the substance of the spreadsheet that was labeled Valuation 30 and was satisfied that that met the requirements for a payment notice. Court further affirmed that payment notices and pay less notices can be given simultaneously in the same communication. And the last point to flag, arising from this, where's the button? There we go, is that the judge commented that whilst the amended contract was compliant, created a compliant payment mechanism, the standard JCT wording of clause 4.6 in the design and build subcontract does not comply with the Act because it refers to a sum that becomes due at a future date. And that was held, that timing issue was held to be inconsistent with what the Act says. So that's a point to bear in mind. The next case is a Scottish case. FES Limited and HFD, very good. You're on the ball. So this relates to the SBCC standard building contract. It's a decision of the inner house of the Scottish Court of Session, and the relevant terms mirror those that appear in the JCT standard form of building contract 2016. So case considers a relatively simple point, which is whether notification by a contractor is a condition precedent to an entitlement to claim loss and expense in relation to a relevant matter. And the slide here shows clause 4.20.1, which sets out the entitlement to reimbursement of loss and expense, and makes that entitlement subject to compliance with the provisions of clause 4.21. 4.21 introduces a notification obligation. Now, I'm not going to spend much time on this because the court concluded with admirable brevity that the wording of these two provisions read together and in the context of the contract as a whole was clear and unambiguous, and that the provision of notification was a condition precedent to an entitlement to claim loss and expense. The court decided that any other finding would deprive these words highlighted on the screen of their meaning, and there was no basis for making that finding. The court did comment that if the issue had been around the timing for giving such a notice, there would have been more latitude, more flexibility. But the fact of the matter was that no notice at all had been given here, and a notice of some form at some point was a condition precedent. Case number 4 on JCT contracts. This relates to termination provisions under the Design and Build Contract 2016. And put 8.9.1 on the slide there. This is the provision that says if the employer doesn't make payment by the final date for payment, the contractor can give notice specifying that non-payment as a default. If the default continues for 28 days, the contractor can then decide to issue a further notice terminating its employment under the contract. So far, so clear. The issue that this case addressed was about repeated incidents of non-payment. So 8.9.4 of the D&B contract says that if the contractor, for any reason, does not give the further notice referred to in 8.9.3, so non-payment, notice of default given, you can then choose to terminate after 28 days. But if you don't choose to terminate on that occasion, and then the employer repeats that specified default, so again, in the subsequent payment application fails to make payment, then within 28 days after that repetition, by a further notice, the contractor can terminate its employment under the contract. The question the court had to consider was, must a right to terminate have accrued in respect of a previous specified default before a notice under this provision, 8.9.4, can be given? The answer, no. That right to terminate doesn't have to have accrued. All that had to happen was the original specified default had to have occurred. So this puts us in a situation where if non-payment has happened on one occasion and has been notified as a specified default, a contractor then on any repeat of that specified default, so any failure to pay in the future, can give a further notice terminating the contract. That is the case, notwithstanding the fact that in this case, the reason that the termination notice in relation to the first specified default was not given was because the employer paid within that 28-day period. And the court said, well, if you read the words "for any reason," it doesn't matter why that notice wasn't given. If it wasn't given, but that same default is repeated, you can give a further notice. So this is, I think it's caused some consternation and is leading to some changes to the way that the schedules of amendments are drafted. But if you have an unamended JCT contract, the court has looked at the wording and told us what it means. With that, back to you, Alison.
Thank you, Garrett.
About mediation.
I'll be very quick. I should say that I think that hexagon case is on appeal to the Supreme Court. So, Mediation. I'm going to be really quick on this because we've gone over on time. You'll all be aware of the Churchill versus Merthyr Tydfil case where the court said that it had power to order unwilling parties to engage in alternative dispute resolution. As a result of that, I think we've seen amendments to the civil procedure rules to allow express power to order the parties to mediate. Recent case, which I thought was worth just a quick mention, DHK Retail versus City Football Group, the trademark dispute between Superdry and Manchester City Football Club. The defendants argued against mediation on basis that I'm sure you've all seen many times before. There were commercial parties with experienced solicitors, and if there was a realistic prospect of settlement, it would have already been reached. There was no realistic prospect of mediation, of success at mediation. Both parties wanted this to be judicially determined, and it was too late. The trial was up and coming. Money had already been spent. The trial was imminent. There was interestingly no suggestion that a mediation would disrupt the preparations to trial, and if there had been, I don't know whether this would have been different. But either way, the courts were having none of this. They ordered the mediation to take place in December 2024. And on the 13th of January 2025, the parties notified the court they'd settled.
Very good.
That's all from us. Other than just to let you know, there are resources available to you if you want to know more about anything we've discussed tonight. We have a construction and engineering blog. We have a construction and engineering LinkedIn page. We have a foundations webinar series. And as Dom mentioned at the beginning, he and I, with some of our colleagues, are about to become internet sensations with our podcast on building safety. Thank you very much.
Thank you. It's a little over time. Sorry about that.
So thank you very much for that. That's really clear. Have you got any questions in the room? Mark?
Yeah, going back to the homeowners with the contractor, the architect, and everybody.
Banker and
else.
Marbank.
Yeah.
Marbank, unfortunately, are insolvent now. If you saw that,
Okay,
yeah.
that was complicated matters. But in that case, obviously, the measure of damages was said to be the cost of the repairs to put them back in the position they should have been in. Was it argued, and how was that squared with Ruxley, where, of course, the lovely case that I heard it in front of Fenwick Elliott being fat bastard with the swimming pool. You may remember. The swimming pool that was only 6'9" when it should have been 7'6".
Yes.
And there, it wasn't the cost of putting it back in its entirety, it was the loss of amenity and limited damages. So how do you square those two? Was that actually ever discussed in the case?
So I don't think that case was discussed in the argument, but I do remember that one, and I think that the difference here was that this wasn't a sort of a simple loss of amenity type situation. This was a house that was not fit for habitation, and the proposed solution was to stick a banister onto a wall rather than deliver what in fact had been.
Make it habitable, but not in the same way.
Not in the same way, yes.
Reasons.
Yeah. So I do think that there are a number of points arising from that case that seemed to have been decided based on a policy of achieving the right answer for the wronged people, and whether or not there will be questions of appeal and whether how that gets applied in other circumstances remains to be seen.
Yeah, I think it's a question of degree when.
Yeah,
it's a question of degree with Ruxley and Forsyth. I think it's not always going to be the case. You can't have the swimming pool that you thought you were getting, and I guess Ranniker falls the right side of the question of degree, and Buxley fell the wrong side. Be how I would put it in layman's terms.
Yeah, I think it was very clear though that once you're in that territory, that there's been a breach of the duty under the Act, then maybe it turns on the having carried out the works in a workmanlike manner or having carried out design in a professional manner. So you're not required to you're not held to sort of an absolute standard, but the standard that would have been achieved if you'd exercised skill and care in a professional manner. I think that's probably where I come out.
We've got another one in the room.
This is very generic. It's almost jurisprudence rather than finer point of law. You mentioned the Defective Premises Act, which I'm very aware of. There's another one that comes to mind, the Occupiers Liability Act. I think that was in the 50s, wasn't it? 57, something like that. Yeah, I don't suppose the law has got a definition of what's defective, because I go into Victorian buildings and terrace buildings, where you can see right through the whole terrace. I have in the past, and you know, we would say that's defective. But so it wasn't defective in Queen Victoria's time, but it would certainly be considered defective now. Is there any sort of definition of how that works? Because it seems to be very temporal in how society regards what's defective. I mean, it's a very wide question, but it's something that exercises me. And I do come across it in reality. I mean, only yesterday I was probably undiscovered a tiny bit at the end of the Third-Party Wall was missing. And I was actually just doing a reinstatement valuation. I mentioned to the owner, I said, and actually she rents it out, so she would have a liability for attendance, I think. I said, that would, in my book, is not acceptable. I'm just going to do a reinstatement, but I think you should reinstate it. I mean, has that ever been tested, what defective means at any given time? Because the building regulations change all the time. You blink and it's new regulations out or a new statute out. Sorry, it's a very broad.
No, well, it's an interesting one, isn't it?
And it just suggests all sorts of things. And I think if you're looking at a contract, it's just whether someone has exercised a reasonable skill and care to be expected in relation to whatever your defect is. So it is almost what was accepted practice in the industry at the time.
Yeah, I think it's very much it's specific to the circumstances. So I was thinking along the same lines. If you're talking about was work being carried out in accordance with a contract, a defect is a failure to comply with that contract. If it's design, a defect is a failure to exercise skill and care. And in relation to the Defective Premises Act, a defect is something that makes the premises, the dwelling, unfit for habitation. So that's what is unfit for habitation is a question of fact and degree. What is a dwelling is another point about what's defined. And then that comes up in student accommodation, for instance.
But that's not contractual.
That's a statutory basis.
Yes.
So I think the question of what is a defect is specific to the circumstances, and the obligation would be to deliver work usually to deliver work in accordance with the statutory requirements in force at the time the work is done. If work is done to a building now, then you don't have to bring the whole building up to the standard of current building regulations, but the work that is carried out must be carried out in accordance with current building regulations.
Yes, it's what your reasonably competent architect had done or designer would have done at the time. And there's a whole load of issues about that in relation to rental.
Victorian buildings not built by
Eddie, have we got any online?
No.
Online. All 100 of them. Not one
That's because they thought they were listening to an hour.
Yeah. They've logged off with their G&Ts.
Then I think we've got one more in the room.
Very first case, BDW. How much money were we talking about in the two blocks where they voluntarily chose to carry out remedial works? I'm just trying to get in my head how much they were in for before
I can't remember. It was millions though.
I don't remember that case, but I know that developers have put aside contingencies of tens of millions for
Mm.
property portfolios.
I might be muddling that with another BDW case, so I don't want to give you an exact figure, but I'm pretty sure it was in the millions.
Brilliant. Well, thank you very much for speaking to us today and answering our questions. Just if you could all join me in thanking Dominic and Alison.